Court of Appeals Division 1 is now in session.
Please be seated. Good morning. This is the time and date set for oral argument in cause number MH210059 in the matter of MH2021 blah blah blah. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel please identify yourself and who you are representing at the beginning of your presentation. Each side will have 20 minutes to argue. Appellant's counsel is responsible for reserving any portion of that time for rebuttal should you choose. Also, we have read your briefs. We have discussed this case in conference. And at this point, I'm going to ask you guys to stay at your podiums. We've squished back together, but COVID is still out there. So, whenever you're ready.
May it please the court. My name is Cynthia Beck, and I represent the appellant. I would like to reserve 2 minutes for rebuttal. Because this matter involved a substantial liberty interest, it was incumbent upon the trial court to ensure strict compliance with the statutory scheme governing civil commitment procedures. Now, the trial court can, of course, control its own schedule, but those scheduling needs cannot trump important constitutional rights. And here, that is going to be those inured from the 14th Amendment due process rights. I would like to address first the hospital's contention regarding overturning In re Jesse M. While appellant feels that that case was correctly decided, it is not really material to an outcome in this case because the holding in In re Jesse M did not confer the right of self-representation on appellant. That was guaranteed to him by the 14th Amendment. And of course, along with rights becomes the concomitant option.
Counsel, was that this issue argued below the JSAM? Was this issue argued below?
No, Your Honor, it was not raised at the trial court.
And then is it waived?
Well, it is our position that it is waived. And that's what we argued. But because I know the court sometimes would prefer to decide something on a substantive ground, I felt the need to address it. But we do contend that it was waived. It wasn't raised below, and I believe the hospital had an option of raising it during the colloquy that the trial court conducted pursuant to In re Jesse M.
You had suggested that the 14th Amendment protects the right to counsel, but that's not what Jesse M held. Jesse M held it was a statutory right that can be waived, right?
Well, I believe that, yes, Your Honor, it is a statutory right also. I believe that the statute that was enacted follows the 14th Amendment, and the 14th Amendment due process concerns raised are protected, but the legislature protected all of those in ARS 36-539. The most important of those being, right to notice, right to counsel, right to confrontation, and right to compulsory process. I think that the legislature was following the dictates of the Due Process Clause by legislatively enacting that.
How does this interact? You at least under JSAM, you have the right to represent yourself, but you have to be competent. It's really odd in this situation where you have a commitment issue because for mental health reasons, and then they have to be competent to represent themselves. How does that all work together?
I agree that there seems, as a threshold matter, to be a conflict there, But that involves conflating competence with mental disorder. All that's alleged in the civil commitment process, and again, at the beginning of this hearing, they are just allegations. Nothing has yet been proven. All that's alleged is that a person is suffering from a mental disorder. As a result, is either a danger to themselves, to others, or are persistently or acutely disabled, taking the gravely disabled allegation out for purposes of this argument. But I don't think that there's anything that addresses competence. And as a matter of fact, I believe it's 36528, gives the patient the option of hiring counsel to represent him or her, and which obviously indicates that there's at least the capacity to enter into a contract. So there's not a competency determination. There's not, whereas in the criminal context, by contrast, there is a determination whether or not the person has a mental illness, that they are nevertheless able to understand and assist in trial. In this case, there's not a competence finding.
Could the hospital have raised that issue?
I believe that the hospital could have raised that issue, Your Honor, and I believe that in Re Jesse M, I believe it's subsection F in paragraph 30, when they're going through the colloquy the court should think about when they're deciding whether a waiver is knowing and voluntary, that they should consider, that's the catch-all one, certainly if there were other concerns about competence or capacity that could have been raised at the child court level.
Counsel?
Thank you.
I'm sorry.
Go ahead.
No.
But, obviously, I think both parties have pointed us to criminal cases by analogy, and I'm not sure exactly how squarely that fits, but correct me or help me walk through this a little bit. You have a right to represent yourself in criminal proceedings, and if something comes up during the conduct of your self-representation that gives the court reason to doubt your competence, I mean, there's plenty of cases that say court has to sua sponte even sometimes kind of revisit that issue, and can also revoke self-representation if your behavior in the courtroom is detrimental to the ongoing orderly process of the trial. Is that kind of a fair summary of it all?
Absolutely, and we agree that the trial court has a very difficult, what am I trying to say? Because of the allegation that there is a mental disorder and that the person is unwilling or unable to participate in voluntary treatment, I understand that this creates a higher burden on the trial court in the context of waiving important rights. And the main reason we think that In Re Jesse M was correctly decided is because it does provide a great deal of guideline to the court to make sure that that initial waiver is knowing, it is voluntary, it is an intelligent decision, understanding the negative consequences to the case that may inure from that.
So let me kind of see if I can complete my thought, which is, in this situation, we have, assuming that I agree with you, either that Jesse M was rightly decided or that they haven't preserved that issue. So we're operating under the world of Jesse M here. And the court lets your client represent himself for a while, and then at some point his behavior becomes troublesome to the court, and the court then revokes that representation. And I'm not asking you to concede that it rose to that level here, but you agree that at some point that could happen, and that would be fine.
Certainly, and had he been given the chance, honestly, to conduct his own defense, it could have happened in this case. What we're seeing is that revocation has to be based on something in the record that supports that he was not following the rules or being serious. I believe the cases from the phrase from the criminal cases is that you have to be serious and obstructionist.
Yeah. So taking their argument at kind of the best possible light for them, and I'm not saying we have to do that, but he said something crazy, which is, according to the court, kind of, if you read the record, said this doctor who the court actually knows speaks English very well, doesn't speak English, that's why I'm going to object to the stipulation or oppose the stipulation. That doesn't, when a defendant or a respondent, a patient, says something that is just clearly inconsistent with the court's knowledge of the reality of the world at the time, that's not enough to trigger a court's finding that I'm not comfortable with you representing yourself anymore?
No, Your Honor, because what the court did was interfere with another very important fundamental right, and that is the right to confront the witnesses against him and to cross-examine the doctor. Had that cross-examination gone down a road that was obstructionist or the behavior was in some other way excessively argumentative, I mean, I can think of a number of things that could have happened had he been allowed to exercise his right to confrontation. The problem here is that we don't know what he would have done because he was cut off when he was still just trying to articulate why he wanted to
I think he
confront the
said something like,
witnesses
he doesn't
against
speak
him.
English, and then the court responded, and then he said, there's other reasons, and the court said, we're done, essentially. Is that kind of your take on the record?
That is my recollection of the record, yes.
So does it really matter what his reason for not stipulating was?
It is our position that his reasons for wanting to exercise his confrontation right are not important. What is important, and I believe the court was well within its discretion to advise him that he had to follow the court rules, and he repeated that numerous times. I think the court was within its discretion there. But when it cut him off, and from this record, it appears because not so much that it was because he was offended by the patient's perception that the doctor didn't speak English well, but because of time constraints with the court calendar, because how we always do it is by stipulation and stipulation not to the affidavits, those are already in, but stipulation to the affidavits in lieu of testimony and cross-examination.
Let me push you on that a little bit.
Okay.
If the patient had said, I'm not going to stipulate because those green men standing behind you are going to shoot me if I do, that would certainly rise to the level. I mean, if the fact that he stated a reason, if your patient had said, I don't have to give a reason, I'm just not going to stipulate, easy case, right? If he gives a completely outlandish reason that really calls into question his ability to perceive and manage events and grasp on reality, you'd agree too, that would give the judge a reason to revoke representation.
Perhaps a reason that's, we could speculate about a possible reason. I don't disagree with you, but I would think that it would be incumbent upon the court, who's already decided this person was competent to waive the right. I would think that would call for at least a follow-up question, just to try to get an understanding, rather than just get frustrated and say, no, this is how we always do it. If you want to exercise all of your rights, then we're going to reappoint counsel. All right, and because there is no body of law in the civil commitment context with regard to revocation, we do urge this court to adopt at least some of the tenets from this revocation of self-representation in the criminal context. Certainly they're not the same because we don't have the Sixth Amendment guarantee in the civil context, so not everything is going to apply, but there are at least two points that I think this court should adopt when deciding whether or not this revocation is supported by the record. And the first is that once the person is allowed to represent him or herself, the court must respect the person's choice how to conduct that, even if the court thinks it's not wise. And that's from State v. Hidalgo. And the other point we'd like to make from that is that the self-representation should only be terminated if the person is either unwilling or unable. And that would go back to the judge's point about, if they're not able to follow the rules because they think that there's green men controlling it. I mean, there could be lots of reasons why the behavior would be serious and obstructionist to the orderly process of the hearing. And that's from State v. Gomez. And so we'll just conclude in saying that the court abused its discretion in revoking the right to self-representation that is guaranteed by the 14th Amendment. Because the court did not strictly adhere to the statutes which guarantee the patient the right to cross-examine the witnesses, then there was no strict compliance with the statute, and we invite this court to vacate the COT. I have a great deal of time left. Are there any more questions?
One quickly. Assuming we find error in the revocation, why, and assuming we don't find that unlike the criminal context, any error is structural, what is the prejudice that your client can point to say that we should reverse the decision?
Well, in addition to the detriment, the deprivation, let's say, of the confrontation right,
But he had an attorney who then stipulated. So why doesn't that cure any deprivation?
Well, because the client, in order to exert his right to confrontation, he had no option, it appears from this record, but to waive counsel. And under Arizona, ARS 36537, that sets out the duties of counsel, counsel's required to discuss the possibility of stipulating to any evidence with the client. We assume from this record that the counsel complied with the statute. So in order for this particular patient to exercise his confrontation right, it appears from this record that his only option was self-representation. He wasn't able to do that. And then the other prejudice is that it's a very high burden for the hospital to prove the disability by clear and convincing evidence. When the evidence isn't tested,
Is there anything in the record you could point to show that the attorney either did or did not consult with his client, get his client's consent to the stipulation after representation was revoked?
No, Your Honor, the record is silent as to that.
What do we do when a record is silent as to something?
I mean, I guess we could have remanded it to develop the record on what counsel's performance.
Okay.
But because the statute enables counsel to enter into stipulations in lieu of testimony, we did not elect to do that, but that is a possibility.
Thank you.
Isn't the prejudice that he wasn't able to represent himself?
Well, there's a great deal of prejudice to not being able to conduct his case in the manner in which he wanted to conduct it. And there's prejudice because he wasn't able to exercise one of his fundamental rights. And then there's prejudice that the hospital's evidence was not subject to testing. And particularly when the judge seemed to have a professional admiration, these affidavits shouldn't stand alone as evidence. They should be subject to testing if the patient wishes to do that. The patient was not going to acquiesce to the determinations of counsel, the determinations of the physicians, which, we're not suggesting that the affidavits were, there was some problem with them, although in this case there were certainly procedural defects with regard to this affidavit. This matter had to be continued once and then recalled again to address these procedural defects. Because there was no ability to cross-examine this particular physician, we don't know if there were substantive defects in the affidavit.
So I realize the record is silent, but if he talked with his counsel after counsel was reappointed and he agreed to this stipulation, then there's no prejudice and no lack of confrontation, is there?
Well, I would respectfully disagree, Your Honor, that he was prejudiced by not being able to test the evidence, as is his right. Once counsel was reappointed, we give a great deal of latitude to counsel in these cases to make strategic decisions that they think are in the best interest of the client. Where the client disagrees.
But doesn't that just point to in your view, the real prejudice is not being able to represent yourself and make the necessary decisions? That's a real prejudice. It's not the inability to cross-examine the witnesses, because arguably he consented to that.
All right. I will concede your point that he did tacitly consent to that once counsel was reappointed, because that is what happened. The stipulation to the affidavits in lieu of testimony was entered.
Why would you say that he tacitly consented? We have a record that doesn't say one way or another. It seemed to me, in light of this circumstance in which he had explicitly rejected it, there should be some burden on counsel or the court to inquire as to whether he's withdrawn his objection. Wouldn't you say?
I completely agree with you, Your Honor, and there were a number of problems with this, and it felt like in the reading, although he didn't specifically say that, but it felt like the court's focus on expedience and getting through this case the way they always get through these cases, which is by stipulation in lieu of testimony, that that's what was going to happen here, and then counsel acquiesced, which seemed to me to be over the client's objection, but at that point, he at least tacitly
I mean,
acquiesced.
the last word we have in the record is from the client is saying no. And then we don't have any kind of correction or supplementation of that by new counsel saying, I've now spoken with my client, he understands, and we stipulate.
That is true. The client never answered that question, never on the record agreed.
Or through
Or
counsel.
acquiesced,
Agreed.
correct.
Okay. You have 50 seconds left.
Oh,
Save it for the-
thank you.
Thank you. Counsel, when you're ready.
Good morning, and may it please the court. My name is Joe Branco from the Maricopa County Attorney's Office, and I'm here on behalf of the petitioner appellee. Before I get into what I think is the heart of why Jesse M. is wrong, which is the legal paradox that it creates, that this court has already addressed, I want to address some of the things that just came up now. One of those is the idea that there's nothing in the record one way or another. The last word is that the client said no, and we don't know what counsel did after that. I think notably absent from this appeal is any allegation of ineffective assistance of counsel. Similarly, notably absent is any actual prejudice or any actual harm raised in the opening brief, other than the fact that this particular patient who wanted to represent himself was not allowed to do so. And I think
Isn't
that's...
that prejudice enough?
No, Your Honor, it's not. If you look at In Re Jesse M., in particular, I believe it's paragraph 32, the court is able to assess, using the rest of the record, whether or not there was any prejudice from the inability to represent oneself. And notably, one of the things that the court relied on, in fact, primarily relied on, was the petition for court-ordered evaluation, the petition for court-ordered treatment, and the 2 affidavits. And so all of that is already in the record. And this really goes back then to that legal paradox, where at a hearing in which a patient's mental health status is the ultimate issue, you've got the superior court who must determine at the outset of that hearing whether the patient can knowingly, intelligently, and voluntarily waive the statutory right to counsel.
Counsel, before you dive into the merits of Jesse M., just want to make sure we're all square. When the patient asked to represent himself, did you or whoever was handling the trial object, saying that either there is no right to counsel or that Jesse M. was wrongly decided?
No, Your Honor, and I don't think that matters.
Well, I'll disagree with you completely on that, but we'll proceed with my question. After counsel was, or after he was allowed to represent himself, did the court, or during the process of allowing him to represent himself, did you or your client object to his ability, say he wasn't qualified, anything like that, saying he's a mental health patient, kind of a tacit challenge to Jesse M., saying that this shouldn't apply because he himself is not competent?
I didn't handle it below, but no, there's no indication that the petitioner's counsel objected in that way.
Okay.
And
So I'd like you to develop the argument that Judge Morse vehemently disagrees with you on. Why do you think it doesn't matter that you objected in the lower court?
it doesn't matter, Your Honor, because it's a lower court. It's required to follow Jesse M. This court and the Supreme Court have made clear in Sell versus Gamma and Francis versus the Arizona Department of Transportation that a lower court cannot refuse to follow the rulings of a higher court. And so we could have raised the objection, been run right over by the trial court, who said, I'm in a judicial hierarchy here, I don't get to make that call.
But
That's
doesn't
why-
that preserve the issue for appeal?
Not necessarily, Your Honor. This court, of course, can consider something for the first time on appeal if it involves a constitutional issue, which we have here, if it's an issue of statewide importance, which again I would argue we have here, and something that's a purely legal question. And again, whether or not Jesse M. was rightly or wrongly decided is a purely legal question. I would also note for this court's benefit, for this panel's benefit, that I believe a similar issue is being looked at by another panel of this court in Torres versus JAI Dining, that's number 1 CA-CV19-0544, with respect to whether or not a litigant interpreting a statutory scheme can raise it for the first time in appeal. That one has nothing to do with mental health law, it's dram shop liability, but I just wanted you to be aware that another panel is currently considering that.
Under specific instruction from the Supreme Court to consider the issue.
Yes, and they raised it for the first time on appeal, just like I am now. So, understanding that this court may not be inclined to reverse a 15-year-old decision, I think that there are some other issues that need to be considered that were just raised. One is, as I said, that the idea that interfering with this by itself should lead this court to vacate a treatment order is wrong. If Jesse M. remains good law, then its analysis guides this court. And as I said, in that case, the court looked at the totality of the record to determine whether or not the patient's inability to represent himself was the kind of error that requires vacating a treatment order.
Counsel, if we were to disagree with you and do that, what would the consequence be below?
So you're saying, Your Honor, if you disagree that you could follow Jesse M. and consider the totality of the record, and it gets remanded?
Yes.
If it gets remanded, I imagine it would have to be a mulligan, or it'd have to be a do-over. But of course, the immediate impact would be, right, the vacating the treatment order for failure to strictly comply with the statutory scheme, and I'll talk about why I don't think that's a proper result.
Would the patient be released pending new proceedings, or what would happen?
It's my understanding, and again, I don't practice these cases at the trial court level, but it's my understanding that when these types of orders are vacated, at that point the petitioner would have the ability, again, assuming however many months down the line we are now, that this individual still needs court-ordered treatment, that would be the process, Your Honor.
Thank you.
When you look at this case, what is different for me when I look at it is we have the right to represent yourself being one issue, and the second issue is he raises a valid argument. I'm not going to stipulate to that evidence. I want to challenge it. So it's kind of twofold for me. Does that make any difference to you or your argument?
It does, if I can push back a little bit, Your Honor. I would agree it does make a difference. It would make my job much harder if the reason given on the record by the patient was that. For instance, if the patient said, I believe that this doctor doesn't have good command of the English language, and therefore it interfered, and of course I'm not expecting a patient to be this articulate, but the patient said, therefore it interfered with the statutorily mandated interview and evaluation, we could have that. That would be very good reason to want to hear from the doctor directly. It's not what we have here. In page 14 of the transcript, the patient says, I think it's clear and obvious from one of the affidavits that one of my doctors does not have command of the English language. I don't think you'll, and again, this is directed at the Superior Court, I don't think you'll be able to interpret his writings about me, about our interview. So the issue is not one of communication between the patient and the doctor. The patient was attempting to raise an issue of communication between the doctor and the Superior Court. And of course, the Superior Court has the affidavits in front of him. And this court has those affidavits as well, and can make that determination on whether or not that testimony that's going to be developed is necessary. And so I don't think that that's an invalid reason, particularly given what the Superior Court went on to say about having nearly 5,000 proceedings, as the judge estimated, having this doctor. So I don't think that that's an invalid reason on that issue. And then it's really when the patient then comes back and says, well, let me respond to that. Let me tell you two more things. At that point, the court revoked representation.
Doesn't it do us a disservice to not understand what the next two things were? Maybe we don't agree with one, but he's got a point on 2 and 3, which we never got to address or hear.
It's true. And, Your Honor, I think the fault for that lies then in the patient's counsel stipulating And again, I'll note, there's no allegation of ineffective assistance of counsel on appeal. This is almost like a backdoor way to raise that without actually raising it at this point.
We almost never allow ineffective assistance of counsel, at least in criminal cases, to be raised on the direct appeal. That has to be a separate PCR type of proceeding.
It can, my understanding is it can be raised in mental health proceedings if it goes toward the due process protections. Because at that point, it's almost like the flip side of the coin of what I'm trying to argue in terms of why Jesse M. should not be allowed. Jesse M. gives a bedrock foundation for protecting the due process of the patient. And so if you're raising, for instance, that the patient's counsel failed to follow the minimum statutory responsibility, at that point, right, that's tantamount to an ineffective assistance of counsel, and that can absolutely be raised on direct appeal because it goes toward those due process protections. And that's really the problem with Jesse M. Jesse M. puts the Superior Court, it puts this court in a very bad position in trying to determine how to give that patient due process protections. And I think as we've argued, the legislature has resolved that tension and does not give an opt-out to allow the patient to continue by themselves. Notably, I do not believe Jesse M. ever says that a patient has the right to self-representation. It's really a de facto byproduct of the ability to waive the statutory right. Additionally, the case that it relied on, which had to do with waiving your presence, even if a patient waives his or her presence, that's buttressed and backstopped by the attorney being present. I do not know how anyone could possibly say that if the patient first waives the right to counsel, court adopts it, and then the patient waives their presence and there's no one there to put on evidence or do anything else, ask questions, how that could possibly afford due process protections. And I know that that's an extreme example, but that's next. And so the legislature, yes, Your Honor.
Jesse M., let me ask you a question. I read Jesse M. as being a case involving statutory interpretation. Do you agree with that? Or
yes.
Okay. I know that there's kind of an underlying due process type 14th Amendment issue, but that Jesse M. didn't decide whether there's a constitutional right to represent oneself in the involuntary commitment proceedings.
Correct, Your Honor, and nor was that raised in the opening brief.
Okay. So let me then, now that I've lured you into my trap, our Supreme Court recently told us in State v. Brinovich, Board of Regents v. Brinovich, I think it is, that matters of statutory interpretation, especially stare decisis, is even more important. And they cite, well, look, there's this 40-year-old interpretation in this case. We've got a 15-year-old interpretation of statutes here. So why should we revisit Jesse M.?
I think the court should address it for three reasons, right? One is, as we noted in our briefing, this is not a case, Jesse M., that has a body of case law developed around it. I mean, how many times did both parties write, there is no Arizona rule, statute, or appellate court decision that addresses something as simple as the standard of review? There are some unpublished cases that have reviewed it de novo. There are many others that look at it as an abuse of discretion. In fact, abuse of discretion is what opposing counsel suggested. And by the way, abuse of discretion doesn't exactly sound like strict compliance with the statutory scheme that leads this court to automatically vacating a treatment order. And so that's one reason why I don't think one of the principal reasons for stare decisis is present here is because there simply isn't any law that's been developed around it. The second reason was this court has an escape hatch from stare decisis, right? So that is...
Is that right? I've always said stare decisis. Is it decisis?
I don't know. I'm trying to learn Latin now, and I'm terrible at pronunciation. All I know is that a V is pronounced like a W, but that doesn't help us on this one.
Yours sounds better, but it just...
Tomato, tomato, fellas. Moving on.
So the case that we cited, Castillo versus the Industrial Commission, talked about if prior decisions are based upon clearly erroneous principles, and obviously that is the main thrust of our argument on appeal, is the legal paradox that Jesse M. creates and that we believe the legislature has resolved for the courts, and that there really isn't a need to continue with that. The other escape hatch would be that conditions have changed. And we addressed, I believe, some of the subsequent legislative history where the waiver of the right to be present is expressly adopted into the statutory scheme in 2009. So that's 3 years after the case, blah, blah, blah numbers, that would have allowed that waiver, and 2 years after, or excuse me, 2 years after Jesse M. And what the legislature did there was expressly adopt the ability to waive the right to be present. Doesn't happen with the right to counsel. And at the same time, strengthens patient's counsel's ability and powers in a superior court. And so I think that's the trajectory, is that the patient's counsel is a fundamental role in this process.
But you talk about the paradox, but with allowing self-representation in commitment proceedings, but other jurisdictions clearly allow it and have statutes on point. And the fact, so does your entire argument hinge on the fact that there is not a statute authorizing it in Arizona?
Yes.
Preclude us from finding?
Yes. So Washington would be a good example of that. And I believe we cited in Re JS in there regarding, I cited it with respect to abuse of discretion standard. The statutory scheme in Washington says if the, and I'm paraphrasing except for this part, so elects, if the patient so elects. And so they give the option to the patient. There is no option here. The option, the court shall appoint appoint counsel for the patient. And so other state courts that have looked at this, and that Montana case that I cited, I think does a very good job of providing a litany of different approaches. They start with one of two things. Constitutional provision, not relevant here because our constitutional provision expressly talks about criminal prosecutions. And other courts have concluded that as well with respect to their particular constitutions, Washington being one. But in Washington, they focused on the statutory scheme saying if the patient so elects, if the patient so elects. And we don't have that here.
Doesn't your argument about the waiving the presence kind of undermine that? Because, following the Brinovich reasoning, this decision was on the books in 2007. In 2009, the legislature tinkered and made some changes to statute, but didn't overrule Jesse M. So what do we make of that?
I think it would be odd, although not unheard of, particularly in Title 36, to say, no, you can't waive this, particularly when they are allowing other examples of where they can be waived. So I say it's not unheard of because there is in 36-536, B says the notice provisions of this section cannot be waived. However, part of that notice says counsel shall be appointed by the court. And so perhaps the subsequent legislative history is muddy. And perhaps that doesn't move the needle. But it remains the case that there is no express opportunity for waiver in the statutory scheme. And again, having patient's counsel there is a fundamental requirement of due process. A few other items that were raised earlier that I want to tick through if the court will allow me. And of course, I'm happy to answer any other questions. As I noted earlier, the opening brief did not raise any issue regarding the buttressing of this right to self-representation under the 14th Amendment. I'm not aware of any case that has decided that. Counsel said, well, at this point, when you've got these petitions in place, these affidavits in place, nothing's been proven. True enough, but I would direct the court's attention to paragraph 32 of Jesse M that relied exactly on those documents. Additionally, there was an unpublished decision in a footnote that opposing counsel relied on that did something similarly. The capacity to enter a contract came up. And I thought that was pretty interesting because the statutory scheme doesn't talk about the ability to afford an attorney. It talks about the ability to employ an attorney. And of course, it could very well be that a patient can't afford one, but it also could be that they don't have the capacity to contract. I think that's another legislative indication that patient's counsel is required, is not optional. As I already mentioned, but I think it bears repeating, there hasn't been any specific prejudice, harm, or ineffective assistance of counsel raised. Those stipulations then are, as they normally would be, the patient's stipulations. And I understand that this is a somewhat unique framework to look at that, but that's where the record stands today. The record, of course, is the responsibility of the appellant, not the appellee. If there was any question about that, it was appellant's responsibility to go back down to the trial court to firm that up. One of the issues that came up is, and I apologize, I'm out of time. We respectfully request that you affirm the court's decision.
Thank you, counsel. Your 47 seconds.
Very briefly, I just wanted to take issue with one thing. The council talked about the only time in the statute it says that certain things can be explicitly waived was with regard to notice. But that's the petitioner's burden. The petitioner can't waive something that would be to the detriment of the rights of the patient. The patient is the beneficiary, so the patient can waive. And I'll just end with that. Thank you very much.
Thank you, counsel.
Thank you both for your arguments here today. We are going to take this matter under advisement. We will issue a written ruling in due course. At this point, we are at recess, and we're going to remain on the bench and let them reset the courtroom because I'm gimpy and it takes me a while to get down and back, so I'm staying here.